Welcome to Financial Insider Weekly. I'm your host, Michael Gray, CPA. My guest today is Naomi Comfort. Naomi is an attorney, and her law firm is Silicon Valley Elder Law. Naomi has taught continuing education courses on fiduciary income taxation and other subjects for CPAs, attorneys, and the public. And though she has found her niche working in the elder law area. And so today, Naomi and I are going to be talking about the use of powers of appointment to provide asset protection and flexibility. So as we get started on this, I'll just, as usual, caution our viewers that this is a complex subject. They have whole courses on this sort of stuff, and so this is really just an introduction, hopefully for a continuing conversation with your own attorney or advisors. So with that, Naomi, thank you for joining me again today.
Nice to see you, Mike.
Okay. Now, when individuals leave money to somebody, they often do it with strings attached. Maybe people don't really know that they can do that, but anyway, we can talk a little bit about that. Anyway, in some ways, they continue to exert control from the grave. So how does that work, and what do you think about that?
I think a lot of different things about that.
Yeah.
So control from the grave is something that has been around for hundreds of years at least. And oftentimes people who have accumulated money, whether it's huge amounts of money such as Rockefellers and you know, some of the big famous names that we know, or modest amounts of money, they want their money that they haven't spent during their lifetime to go to certain people or certain causes, but want it used in a particular fashion, or sometimes just not used in a particular fashion. So rather than leaving money outright to somebody or some organization, they'll leave it in trust with restrictions on how it can be used. This is done oftentimes to give us tax planning that we want to accomplish for somebody, or it could give asset protection planning so that creditors can't reach the assets of money that's been inherited. There are lots of different purposes that can be served. And what do I think about it? Well, it allows people to leave money consistent with their values and their wishes, so it can be a very good thing. Too many strings can be a bad thing.
Yeah.
Too many strings can make the administration and utilization of the funds cumbersome, can result in costs that exceed the benefits that are going to the person or the cause that you hoped it to go to. Circumstances change, and the document might not give flexibility to deal with those changed circumstances. So strings come with strings attached.
There you go. Yeah.
Controlling from the grave is a little difficult.
Yeah.
Can be done, but it can create other problems also.
Yeah. So one thing, I guess, is that when you have pretty modest amounts, you know, I guess it's sort of like don't sweat the small stuff. You know, to have a $10,000 trust just doesn't really make any sense. Just give them the $10,000 and okay, whatever they do, they do.
Right.
And where if it's, you know, much more significant amounts, then you have something really worth protecting and worth working with.
Correct. So one of the things that we see quite often is when you've got a complex family, second marriage, kids from prior, and the spouses, they want to take care of each other so that when one dies, the estate is left intact for the benefit of the survivor, but they want to make sure that their assets go to their own kids when the surviving spouse passes away. So they don't want to give their assets to their kids at their death if they're the first to die, because that would impoverish the spouse, because it would take, this is the estate in my hands.
Yeah.
It would take the estate, and it would take money away from what had been being used by the couple, and the survivor would only have a portion of those assets left to live on. So it would take the money away from the survivor and impoverish them. So they don't want to do that. They want the money there for the use of the survivor, but they don't want the survivor to then take what's left of all the money and when they die leave it all to their kids, as opposed to leaving some to the deceased spouse's kids. So they want to keep some control. They don't want to just give it outright to the surviving spouse. They want to give it with strings attached and control from the grave. The surviving spouse can use the money, maybe the income, for health, for maintenance, but can't just give the money away. And when the spouse dies, the spouse can't say where the funds go. The first spouse to die says, no, my funds, once my husband's gone, my funds go to my kids. You don't give them to your kids, they go to my kids.
Yeah.
So that's where we see, that's the most common use of control and strings that we see in an estate planning practice.
Yeah.
Another very common one is when you want to protect against the beneficiary's imprudence. If you have a beneficiary, a child who's going to inherit money, who's a spendthrift, and you want to protect it against their creditors, then you might give it to them in trust so that they don't actually get their hands on it. They only get pieces of it. Then their creditors can't attach the assets that are still inside the trust and can't compel the trustee to make distributions to the creditors. And that's used for situations where the person doesn't use their brains well when it comes to money, doesn't make good decisions, or maybe the parents don't like the spouse that their child has, or maybe the child is a professional, subject to like an attorney or a doctor who is really subject to being sued, and maybe something might happen and their insurance might cover it. These assets are protected from lawsuit that way. So we like to lock things up. We have reasons for locking things up in trusts, and otherwise.
Yeah. Well, you want to have a reason for it because it creates a lot of difficulty for the people who have to live with the trust.
Exactly. So that's the asset protection piece of it. It's protecting the assets so that if you've left them, for example, to your spouse, you can control what happens in the end with them. If you've left them to a kid or another beneficiary, but you've left them locked up in a trust, it protects them against creditors, spouses, other people who want to get to them. Maybe it's a special needs trust so that the person with a disability can qualify for needs-based public benefits. That's the protection part of it.
Yeah.
That's the control from the grave.
Okay. So we'll get into some more things here in just a second. But before we do, I just wanted to come back to this because I have a personal experience there. I'm not going to relate it, but maybe more just to make a comment, and that is when you have the situation of you've got the surviving spouse and the kids, let's say, of the other spouse, you're going to have a lifelong conflict between these people because the surviving spouse is going to see the kids as a nuisance, and the nuisance are going to see the surviving spouse as an obstruction. So, in other words, she's standing between me and my inheritance, and, well, people have committed serious crimes for less. Anyway, so I hate to say it. Anyway, so if you can, I just encourage people to think about that as far as an estate issue, and maybe you can provide for something, using life insurance or something else. Not everybody can do that, but if you can, it may be worthwhile, or maybe to get some of the stuff free of trust to the kids, and then have another piece that's there for the surviving spouse, so she has a little more security in her position.
That's something that we counsel our clients about quite a bit, because it is quite conflict, and the remainder beneficiaries do have an interest in that trust. And they can really intrude on the life of the surviving spouse.
And what's income and what's not, and I mean, it creates all of these issues and litigation. So darn, it keeps the attorneys employed.
Controlling from the grave keeps the attorneys employed. This is true.
Okay.
This is true. But sometimes that control from the grave is the only way to
Yeah.
accomplish the primary objectives and goals of the
Yeah.
settlor, and so that's how we do set it up.
Yeah.
And so that's actually the situation that I think we're going to look at today at different issues and setting up those trusts and those transactions where we want to maintain control from the grave or maintain control after giving away a gift. We want to give it with strings attached, but we want the right tax treatment, but we want to have control. But the issue is you can't predict the future.
Yeah.
You don't know what all the changed circumstances might be, and how do you deal with that in the document?
Right. So,
And how do we set things up so that we can get that asset protection, get those strings, but have the flexibility we need to deal with changes that might come up along the way?
right. Because when you're living and you've got a living trust, usually it's a revocable living trust, it's sort of a substitute for a will. So you, in a sense, you don't even know that it's there very
Right.
much during your lifetime.
Right, it's in the background.
And so now suddenly somebody passes away, and now the harsh reality comes in that there really is an irrevocable trust that usually falls out of these estate plans.
Right.
And so irrevocable means supposedly you can't change this document. But what if circumstances do change? What can you do related to that?
Well, that's where the drafting piece is really important, and hopefully the attorney that you have worked with to set up these documents has gone through various issues. So let's stick with one example, because otherwise I think we're going to confuse people. Let's stick with the example of the couple.
Mm-hmm.
The wife has died,
Mm-hmm.
husband is left, wife's assets are in a trust for the benefit of husband. And when husband dies, wife wanted what's left to go to her kids, not to husband's kids, but to wife's kids.
Mm-hmm.
So that trust is going to say, for example, during husband's lifetime, he gets the income and whatever amounts of principal that he needs in order to maintain his standard of living. And it's going to say, at his death, what's left goes in equal shares to wife's kids. That's the ultimate goal, right? Is that it's going to wife's kids. Well, what if something's happened with wife's kids? Maybe one of wife's kids is now disabled and on needs-based public benefits. We don't want those assets to go outright to the child with needs-based public benefits. So we want that document to actually have the flexibility so that husband can change the document appropriately. We're not going to give him authority to be able to leave it to somebody besides her kids, but we're going to give him the authority to change the terms under which the kids might get the money. So for example, in counseling the wife during her lifetime when we set this up, I would have talked with her about, well, do you want your husband to have authority to change the percentages that people get? Maybe you have 3 kids, maybe one of them should get 50% and the other 2 get 25% each. Maybe he can make that decision at a later date based on changed circumstances that maybe, no, they don't all 3 get something or equal amounts. But if he doesn't change it, then they get equal amounts. And maybe we give him the authority to not change the percentages, but just change the terms. Do they get it outright? Do they get it in trust? Do they get it in a special needs trust? So we give him some flexibility. Wife dies, husband may live another 20 years, right? It could be a huge gap in time before this trust is actually distributing to the remainder beneficiaries. Anything could have happened since then. You know, there could be different relationships, strained relationships. I don't know. That's why I want to put in some flexibility. So that's the type of thing that I like to work into my trust. It's called a power of appointment. And it basically says that the husband can leave what's left in the trust to the wife's children or the wife's issue in such proportions, under such terms as he should determine. So he could say, you know what, all the kids are old enough, they're rich, well, you're going to leave everything to the grandkids instead. Skip the kids entirely, have it go to the grandkids. But it can only go to the beneficiaries she's said. Can't go back to his kids or his new wife. It only goes to the people that she said. So we give it that flexibility so that it can change. So at some point, 15 years down the road, he says, you know what, those kids are all doing great. So he exercises the power of appointment and says, instead of it going to the kids, it's going to go in equal shares to the grandkids. They get it at age 35. And he lives another 5 years. And then he dies. And how does those assets get distributed? They get distributed according to what he said to the grandkids at age 35. And that's usually going to be written up in his will. Not necessarily. The document will say how he exercises his power of appointment, but that's often where it's going to be found.
Yeah. So I think, though, that's something that you just sort of slid through, ends up, in some cases, being very important. In other words, how is it exercised?
Yes.
And so you need to really study carefully the document, because sometimes it says it doesn't, and maybe it can be in a separate document, it could be in the will, it could be in the trust.
Right. So when a person's exercising that power of appointment, when they're deciding, I want to change how this is going to go, again, sorry, but you got to go back and see the attorney to make sure it's drafted right, because usually it has to be specifically exercised, and you have to refer specifically to the document where you're given the authority, and you have to follow the instructions in that document to the T. Okay? If it says it has to be in a will that's been admitted to probate, then that means it has to be in your will, and when you die, that will has to go through probate. Which kind of defeats the whole purpose of having the living trust. So hopefully it doesn't say it has to be admitted to probate. But a lot of the older documents do say that, and I've had quite a few that I've had to go through probate because the document said it had to go through probate, which was unfortunate. So it has to be in compliance with the terms that's giving you the authority to make that exercise of the power.
Okay. So now you've exercised this power during your lifetime. But what if the person changes their mind and now they want to do it differently? Now what do they do?
This happens all the time. So let's go back to our example. The husband, it's been 15 years. He's looking at wife's kids going, they're all doctors and lawyers. They've got boatloads of money. They don't need this. I'm going to leave it to the grandkids instead. So he meets with his attorney. He has a new will drawn up that says, I'm exercising the power of appointment. I leave it all to the grandkids in equal shares. 5 years go by. Let's say we're now current. And the kids have suffered in this economic crisis. And he looks back and he says, maybe they do need the money after all. He goes back to his lawyer and he drafts a new will and revokes the prior exercise. So it's whatever is the last document, that's what's going to be effective in this situation. The last document that he's exercised. So long as he has capacity, he can change what the disposition is according to those terms of the power of appointment.
Okay. Now, this person is going to exercise this power of appointment. Does he have to notify anybody else related to that?
Generally, no. With a testamentary power of appointment, the way those are usually drafted, it puts the burden on the trustee of the trust to find the will to see if there has been an exercise of the power of appointment. And then the trustee is looking after death to find that will and to find the relevant document. If the trustee finds nothing, no will or that is exercising the power of appointment, then the trustee can proceed as though it hadn't been exercised. So in most circumstances, no, there is not a requirement. However, if somebody else is the trustee, I might deliver a copy on behalf of the husband to the trustee during the husband's lifetime, just so that I know that the trustee has it, because I want to make sure that my client's wishes are followed. Where that might be different, and there would be an obligation of delivery, would be in a document that provides a lifetime power of appointment that basically says maybe for 30 days at the beginning of every calendar year, you have the authority to appoint to these beneficiaries up to $20,000 each. Now that's going to have to be exercised and delivered to the person who's going to then distribute the money. So that one's going to be a little bit different. But just saying with our example of the husband and wife, that is usually a private document, so he could change it as many times as he wanted and nobody would know because everything else was revoked and gotten rid of.
Okay. Time is going, but there's a couple of things. I guess I'll throw this one up first because this is sort of state of the art, and so it's not in your questions, but nonetheless it comes into this area of flexibility, power of appointment, and so forth. And so can you maybe talk for a few minutes about a trust protector?
Oh yes, a trust protector. So the power of appointment is an opportunity for somebody to change the beneficial interests, who's going to get what.
Mm-hmm, mm-hmm.
A trust protector is somebody who's designated in the document and is given certain authority. The most common authority that we give to a trust protector is the power to amend a trust which is irrevocable and cannot be amended.
Right.
So the most common authority that we give the trust protector, so these trusts, it's irrevocable.
Yes.
And it's going to go on for years.
Yes.
Not only do the beneficiaries' situations change, but the laws change. And there can be changes in the law or changes in the assets that would warrant a change to the instrument to make it function the way the settlor intended it to.
Mm-hmm.
A trust protector generally has the authority to make a modification to the document due to a change in the law or changed circumstances that result in the document no longer functioning the way it was intended to. So they don't have unfettered rights to go in and change things. It's very, very specific, very limited. Oftentimes they're given authority also to implement removal of a trustee if that is appropriate, that type of thing. Those are the most common situations that we use a trust protector for in my elder law practice. I don't know if some of the other tax professionals, tax practitioners, are using them in other ways that you're seeing in your practice a little bit more than I'm seeing.
Yeah, well, like I said, I mean, this is sort of the state of the art. One of the issues that we have right now, you and I both know, and many of our viewers should also know, is, you know, at the end of 2012, our estate tax system becomes a pumpkin and goes back to where it was before 2001. And so, you know, suddenly to go from a $5 million exemption to a $1 million exemption equivalent and so forth.
Yeah.
And so suddenly, you know, things that would work under one system, you know, just wouldn't work. And so it seems like we need to have flexibility these days in our document that sort of provides the ultimate in flexibility. From what I understand, you wouldn't usually want to have a family member as a trust protector because you've got conflicts of interest and other things that
Right.
are going on. You need really somebody who's really independent. The professional fiduciaries are a ripe group for this, you know. Anyway, you need somebody that you really do trust because you're putting sort of awesome authority in this person's hands.
Correct.
To step in and basically to remake your will for you. So you want to think very carefully about whether you want to do this or not, but it's something to just be aware of now as a choice when we're talking about this flexibility that people need after a death. So I thought it was important in your discussion to just sort of bring it up. Okay, so we have about 3 minutes left, and so I'm trying to think of what else that we should bring. Maybe just real briefly. Some people may have heard, you know, of a general power of appointment and a limited power of appointment. Maybe you could sort of highlight that very quickly, what the
Sure.
difference is and what the difference consequence is.
Sure. So when we're setting up the power of appointment in a trust, we want to give some authority to the power holder to make changes, but we don't want that authority to be so broad that the assets in the trust for tax purposes are considered owned by the power holder. If we give them a general power of appointment, they're considered owned by the power holder. A general power of appointment is authority to designate as the beneficiaries yourself, your estate, or your creditors. So to get the tax planning that we generally want, it's a limited power of appointment in this type of irrevocable trust, because we don't want the power holder to own the assets. So it's something less than that. And it can be just that. It can be as broad as anybody but myself, my creditors, or my estate. Or it can be as limited of a power as only to my children on whatever percentages you decide. So the general power of appointment means it includes yourself, your estate, your creditors. It brings it into your own, the power holder's estate for tax purposes.
Yeah. Okay. Well, folks, we're really just about out of time. Naomi, I want to thank you again so much for joining me. Folks, this will be on the internet if you want to share with your family at financialinsiderweekly.com. Anyway, I hope that you found this of interest, something to think about, and we'll see you next time on Financial Insider Weekly.